Professor Emeritus at Harvard Law School, the author of The Price of Principle. Alan Dershowitz joins me. Good evening, sir. And let me ask you first, and any lawyer in his right mind that would tell the president, if he were his client, to testify before this committee?
No, it's very simple what the president should do. He should go to court and challenge the subpoena on executive privilege grounds, on any other grounds. The mistake that Bannon and Navarro may have made, or maybe the mistake the committee made, is they sought to criminalize the refusal to comply with the legislative subpoena without first going to court. The way it should work is this. If Congress subpoenas you and you refuse to comply with the subpoena, Congress should go to court and demand that the court enforce the subpoena. Then you have no defense at that point. They didn't do that. And so I think both Bannon and Navarro have substantial appeals. Now, Trump can avoid that dilemma by going to court himself. He can bring an action saying, no, I'm not obliged to testify if he wants to take that position because I have executive privilege or I have lawyer-client privilege or anything like that. But if the court then says you must, then he really has to do it. Well, he can appeal, obviously, but if the Supreme Court ultimately rules that he has to testify, just like the Supreme Court did in the Clinton case, then he would have to.
All right, that's the constitutional approach to it, as well as the process of doing it. I'll tell you what struck me about this subpoena. I've gone through it, and it's a number of pages. For the life of me, I do not understand this. We've got people on that committee. Liz Cheney's a lawyer. Adam Schiff's a lawyer, was a former U.S. attorney. In the first paragraph to President Trump, this is what it says. We've got the words up on the screen. It says, as demonstrated in our hearings, we have assembled overwhelming evidence, including from dozens of your former appointees and staff, that you personally orchestrated and oversaw a multi-part effort to overturn the 2020 presidential election and to obstruct the peaceful transition of power. To me, if I were the lawyer in this case, it's like, look, they have convicted him in the first paragraph where they say that they're trying to get information from him. They've already convicted him. So you'd have to be out of your mind to appear before an organization that has convicted you. Now, we've heard them say that, and we've heard them say things, but they put it in writing in the first paragraph, thus giving Trump basically cover, I think, to take the Fifth Amendment with people.
Well, he doesn't have to take the Fifth Amendment. He can argue that this is a perjury trap. There's already some cases that say that congressional committees and grand juries can't ask questions to which they already know the answer in order simply to create a perjury trap. That's what they seem to be doing. They say in this first paragraph, we know everything that happened. We've already heard from witnesses. Now we'd like you to come and contradict that testimony. And if you do, we will get you indicted for perjury. So obviously, he should be challenging that subpoena in court before he has to make the decision whether to testify. If he loses in front of the federal district court, he can still go to the Court of Appeals in the United States Supreme Court. By that time, the midterm elections will have taken place. This committee may very well have been disbanded. And so I think we're seeing a lot of theater here and not a lot of real law being practiced.
All right, when you talk, let's say we're far down the road. Let's say that he's been compelled by the court to testify. Let's say he's exhausted all privileges. Let's say that he testifies. In terms of executive privilege, they say they want to talk to him about communications with people who didn't necessarily work for him. Are those things ever protected by executive privilege for a president? If I know that if his chief of staff is having a conversation with him, but what if he's having outside conversations with people who don't work for him about this?
Well, Judge Nichols today correctly pointed out in sentencing Bannon that the law of executive privilege is not clear. It's up in the air. He certainly has the right to claim that. Now, whether the courts will sustain it, we don't know, but everybody's taking the shortcut. Instead of going to court and saying, does Bannon, does Trump, do they have executive privilege in conversations between a sitting president and somebody who is not a chief of staff or not in the White House? Do they have executive privilege? Judge Nichols doesn't know the answer to that question. I don't know the answer to that question. And certainly the members of the committee don't know the answer. That's up to the courts. And until the courts decide that issue, there should be no criminal prosecutions. This is Alice in Wonderland. Criminal prosecutions first, then we'll decide what the law is. That makes no sense.
All right, Senator Lindsey Graham asking for help from the Supreme Court, essentially quash the subpoena for him that's coming out of a Georgia grand jury. Your thoughts on that?
the Supreme Court's not going to intrude in an ongoing investigation. They'll probably deny cert, and then he will have to make a decision whether or not he can testify and whether or not he can invoke congressional privileges. There are congressional privileges too.
But let me ask you, his, though, isn't a congressional hearing that's asking for the testimony. It is a sitting grand jury. Very different. Would you agree?
That's right.
Very different.
But remember that Article 1 of the Constitution provides that no member of Congress shall be made to answer questions that directly relate to their role. So there are claims of legislative privilege. The main point is this is not for Congress to decide. With our separation of powers and checks and balances, this is for the courts to decide. Once the courts decide it, and once the courts enforce the subpoena, then, like in the Clinton case, the president, the senator, Bannon, at that point they have no choice other than to engage in an act of civil disobedience or to claim the Fifth Amendment. They can claim the Fifth Amendment. That's an absolute bar. But obviously, we know what President Trump has said about people who claim the Fifth Amendment. So I doubt very much we're going to have him claim that amendment. He says only criminals basically claim the Fifth Amendment. He's wrong about that. Clients claim the Fifth Amendment all the time if they're innocent. They don't want to give the prosecution any kind of information that might be a step in the road to incrimination.
One quick question. Would you agree that President Trump makes up his own mind, probably in some ways is probably the worst client for a lawyer who's trying to give instructions? And he's not a
I can tell you he was a good client. He was a good client when I represented him. He didn't even ask for me to show him my presentation. And of course, I never mentioned the word Donald Trump in my presentation to the Senate, but I've heard reports from others that he's not such a great client. But for me, he was
always a client who's, I suspect he's a client who's got his own mind on this one. Anyway, Professor Dershowitz, thank you, sir.
Always a pleasure. Thank you.